There's 7 new laws in Rhode Island that were passed that are going to impact every real estate investor here in the state. You need to know about this. Hey everyone, Justin Mann, co-founder and managing partner of Stonelink Property Management. But I'm not talking to you today as that. I'm actually talking to you today as a real estate investor. What I'm going to give you is my perspective, my opinion, and my input on the 7 laws that are impacting real estate investors all over Rhode Island. This is not legal advice. I'm talking as an investor first. The first bill I want to talk to you about that was actually passed into law is the escrow account bill. And it's really important. From a real estate investor perspective, you want to collect rent. If you don't have your lead conformance certificate, if you don't have that in every unit, in every building that you have residential real estate investment property, you are at risk of your tenant petitioning the court and having an escrow account established, and the rent that they should be paying you goes into that escrow account. And the only way to get out of that jail is to get your lead cert. So rather than getting stuck in that whole process, as a real estate investor, get proactive, find out if your real estate investment properties have lead certs, and if they don't, you need to get on the ball and get that done. So the second law I want to talk to you about is lead conformance, and it's required for all real estate investment properties, residential real estate properties. The deadline for this is October 1st. Look, there's been a lead conformance certificate that's been required by law since I think it was 2004, 2005. But the new law that passed last year is enforcing the law that was already on the books. So they set a deadline. There's penalties if you don't meet it. We've already established that the escrow account bill is tied to your lead conformance certificate. So as a real estate investor, what you need to be doing is finding out whether or not you have that lead conformance certificate. And if you don't, make sure you get it. Follow the process, get it in place, make sure you track it because they have to be renewed every 2 years. And this is something that you need to stay on top of because of that. But it's really, really important now because the state now has penalties in place. The Attorney General has fines they can impose. And so if you're not following this, there's going to be real penalties for you. And we all want to avoid that. The way to handle it is to get in front of it. Get proactive. Don't wait for the deadline. Get started right now because the resources you're going to need are going to get tied up really, really quickly as other investors start to realize this is a thing and they need to get on it. Law number 3, the statewide mandatory rental registry. It is a way for the state to be able to identify and contact you should they need to do so. And oh, by the way, if you have a property manager, their contact information needs to go in there as well. But this statewide mandatory rental registry, which is being established, it hasn't been built yet, has a deadline for registration of September 1. Get your information in order. Make sure you have all your ducks in a row. Get this lined up so that when it comes online, you can get your information registered without any delay. And this, by the way, is not a big deal. Getting that information inputted is not something extra you need to do other than signing up, getting your information entered in, you're off to the races. Law number 4, banning of application fees. What does this mean? I can't run applications? No, of course not. You're a real estate investor. You know how highly leveraged it is finding and placing good quality residents that are going to stay, pay the rent on time, and take care of your property. What the law says is you can no longer charge some arbitrary application fee. You can, however, charge your actual cost to run the credit and BCI check. The caveat to this is if your applicant comes to you and says, oh, I've got my own and it's within 90 days, then you have to accept that. However, if their BCI and credit check doesn't actually equal the detail and level of information that yours does, there's an argument to be made. Again, I'm not an attorney, but there's an argument to be made that you can still charge to run yours if you have deemed and you can prove that your process, your BCI check, your credit information is more information than what they're providing. Having said all that, you can no longer charge just some arbitrary application fee, but you should never deviate from your process, and you should have a process. Finding and screening and placing the best quality resident is probably the most highly leveraged thing that you can do as a real estate investor. Don't skimp on that process just because the state says you can't charge an application fee. Law number 5, sealing of eviction records. Before everybody freaks out, let's understand there are real limitations and parameters to this, and it can only be done once within a long period of time. So this isn't for the habitual offender. This isn't for that resident that skips out on rent every 12 months and gets evicted and then has to go through this process and is going to protect them. It was really designed, from what I understand, the spirit of it is that resident that might have been paying rent consistently every month, fell on hard times, COVID, lost their job, whatever the case may be, and has that one eviction on their record, and they wanted a way to basically isolate that case and seal it. Me as a real estate investor, I'm not too concerned about this because, again, going back to our screening process, I'm still calling their current landlord or their 2 past landlords. I'm still going to be calling their employer. I'm going to be checking references. I'm going to be making those phone calls, doing the hard work, as it were, to ensure that I set up both parties for for success. So the sealing of eviction records was really designed, the spirit of it was identifying that resident that might have fallen on hard times or had extenuating circumstances, a life event, something happened in a one-time case, and they want to protect that person. That's really what it is. Law number 6, increasing the limit for self-help repairs that a tenant can do. It used to be $125, now it's $500. At the risk of sounding cynical, I have to ask myself, why are you putting yourself in a position where your tenants are having to do the maintenance work that you should be doing? The number one reason that your tenants are going to move is bad maintenance. You don't want turnover. It's the most expensive thing, generally speaking, for a real estate investor. I certainly don't want it as a real estate investor. You shouldn't either. If you want to avoid this whole issue of self-help repairs, just do the work and get it done and make sure it's done right the first time and get it signed off on and keep moving on with your life. Because if you get into a situation where a tenant can legally do self-help repairs, there's been a lot of water under the bridge in terms of time that's led to that. So just avoid the whole thing altogether. Be responsive, get it done, and get out of there. Law number 7 refers to a landlord-tenant consumer guide. The last word is the one I want you to pay attention to. It's a guide. It is not law. It is not necessarily going to be interpreted or even referenced by the courts. We don't know how it's going to be interpreted by the courts. To my knowledge, there is no case law for this. We can look to how the courts have interpreted, if you will, the landlord-tenant handbook that's on the books today. And from our experience, they may have referenced it, but it's not the law and it will never be the law. The consumer guide, by the way, has been written, but they are taking public comment as of today, February 1st. You still have, I believe, some opportunity to give public comment on. So there they are, the 7 new laws that passed in 2023 in the legislative session here in Rhode Island. These are the ones that I think as a real estate investor, you really need to be paying attention to. Again, in my time as a real estate investor in the state of Rhode Island, unprecedented in our history. And so knowing them is going to be mission critical to your success in 2024. If you have any comments, please leave them in the comment section below. If you have questions on this, please contact us. We're happy to help in any way you can.